Good evening. Good evening. Good evening, everybody. Good evening, everybody. First of all, welcome to those who are regulars in this space, to those who are occasionals, to those who are visiting us here for the first time. Please feel most welcome. We call our synagogue the Bayit, which means the house, the home, because we really want this to be a home that welcomes all people and a home that is preoccupied with the concerns and the welfare of all humankind. The biblical character Joseph, imprisoned and wrongfully convicted, speaks to the butler with whom he shares a prison, asking him to remind him to the Pharaoh when he gets out of jail. And Joseph says, Ki gunov gunavti me'eretz ha'ivrim, I've been stolen away from my home, from the land of the Hebrews. V'gam polo asiti me'uma, ki samu oti babor. And here, in this prison, I did nothing that caused them to put me into this pit. It took me a while to realize that was the plain sense of the text. I always assumed that it meant, here I've been able to do nothing because they placed me in this pit. And it seems to me that that's the double difficulty of the wrongfully committed. First, living with the realization that you did nothing to deserve your wrongful conviction, living under the cloud of an injustice and a wrong. And second, living a life that feels like it lacks the opportunities for meaning and productivity that each person dreams of. Joseph ultimately had God's help, but he would have done well to also have Mark Baker's help. We're so proud that Mark is a member of our congregation and congregational family, someone who's devoted his life's work, his insight, his blood, sweat, tears, his eloquence, and I dare say his flair for the dramatic, to helping people who were wrongfully convicted find justice and freedom, people who spent decades behind bars and giving them decades of their lives back. I think in recent years we've all, each in our own way perhaps, become more attuned to the complexities of the criminal justice system and paid more attention to convictions and life behind bars and what it means and the place that it has and should have in our society. And tonight's an opportunity to get a little glimpse into that world through Mark's accounts of his work and his motivations and some of the details of the stories that he's worked on, and listening to his colleagues, to Jeff and to Anthony, and pieces of their stories as well. We're honored to have each of you here, and I'm really honored to introduce my own friend, teacher, Mark Baker.
Joseph actually called me, Rev. Stephen, but I had not kept my bar membership in Egypt up, so I had to defer. All right, this is a PG-13 presentation, but I think the only kids here are my grandsons. There's a couple of graphic discussions of some of the forensic evidence that I'm going to get into, so I guess I don't have to worry about it too much. How do you defend someone who's guilty? I wish I had a nickel for every time I've been asked that question. Let me first read you the Sixth Amendment. You've heard a lot about the Second Amendment. Many of you have heard of the First Amendment. If you're a criminal defense lawyer, you deal with the Fourth, Fifth, and the Sixth Amendment. In all criminal prosecutions, the the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusation, to be confronted with the witness against him, to have compulsory process for obtaining witnesses in his favor, and to have the assistance of counsel for his defense. All, not just innocent, not just guilty, because you're presumed innocent when the process starts. Practically speaking, there is an extremely relative concept to be understood when you talk about guilt. What is guilt? Guilt's a relative term. If I'm a battered wife, and every time my husband has a beer, he beats me up, and one day he says, "Bring me a beer," and instead of giving him a beer, I give him a belly full of shotgun blast, I'm chargeable with murder. Would you treat me the same as someone who stopped you on the street with a gun, took your wallet, and then blew you away? He's also a murderer. So it's relative. What is guilt? It's a very relative concept. In any event, defending the truly guilty is a lot easier. You do what you have to do. You give your defense 1,000% effort. You do everything you can for your client. If your client is then convicted, you sleep at night. Justice has prevailed. On the other hand, what happens when you represent someone who you believe is innocent? That is liberty's last champion, worst nightmare. Think about it. Someone has put his or her life in your hand. You have fervently believed in that person's innocence. You have done all you can do to try to create an acquittal, a dismissal, or some sort of exoneration. And despite your superlative advocacy, your client is convicted. Try to live with that one. That happens more times than I can count. I am a criminal defense attorney. I am not. I never have been. I hope never to be a criminal lawyer. I represent criminal lawyers. For 43 years as a prosecutor and a district attorney, I've concentrated in post-conviction litigation. I don't do trial work per se. And that involves appellate litigation, direct appeal from the court of trial to the intermediate appellate court up to the state's highest court in New York, or in the federal system to the various courts of appeals around the country. You ever hear the expression, man plans and God laughs? It's a Yiddish expression which I don't know, but thank you very much. That's me. I'm a child of the 60s, a baby boomer. After 12 years of yeshiva, my father had the acuity to say, go to an out-of-town school and learn about the world. So I went to Syracuse University. I went to the Newhouse Schools of Communications, studied television and radio, and it was the height of the Vietnam War, so I enlisted in ROTC as an Air Force cadet. My plan, as a smart Jewish boy, was to deal with the Vietnam War as a JAG officer, let the government pay for law school, and then I would go into the television industry and ultimately found the Baker Broadcasting System. Well, 1967, I was diagnosed with an ulcer. Doctor said to me, lucky guy. I said, why is that? Don't ever draft you. I said, you want to say that again? Don't ever draft me? I was about to sign my enlistment papers my junior year in the Air Force. So what's the percentage you're talking about? He said, 90, 95%. Okay. I went with that. I resigned from ROTC, took my chances. When I got out of college, I got that greetings letter about the second day. I went for my physical, and finally I got my 4F. But until then, I was not breathing very well. So I studied television and radio. What was the plan? Go to law school, work for the FCC, learn all the regulations, Television was in its infancy, cable television in those days. Cable TV, CATV was how you brought a signal from the Empire State Building to the mountainous areas in West Virginia because they couldn't signal over the mountains. My term paper, my senior year, envisioned if you can have all these coaxial cables under the ocean and bring a telephone service to Europe and beyond, why can't you do that with a television signal and have like a 24-hour-a-day news network? I'll never forget what the teacher wrote on the paper. Very creative, ridiculous. I was a nuvvy. So I went to Brooklyn Law School, and that was my plan. I'm in my senior year, and I see an ad on the placement office for a volunteer at the Appeals Bureau of the DA's office right next door. Had some free time, sounded interesting. I went in there, they gave me the position. I wrote a couple of appellate briefs, and they were pretty good, I must say. I get a call from then District Attorney Gene Gold to come down to his office. This was graduated in '72. This was January, February. He says, okay, I want you to be an assistant DA. I said, well, it's really not the plan. Here's the plan, da-da-da-da-da-da. Well, to clean up his act, he said, baloney. This is what you're doing. I don't even want to discuss it. Bird in the hand is worth two in the bush. A couple of people I graduated law school were working in Gimbel selling shoes, so I figured it was a better idea to take him up on it. So there I was for 5 years, assistant DA in Brooklyn, arguing appeals in the appellate division and the New York State Court of Appeals. Had a 95% success rate. I ultimately became a special assistant attorney general in what was then the special prosecutor for corruption in the World Trade Center, where we prosecuted police officers and judges and correction officers and lawyers, all connected with, came out of the Knapp Commission. If anybody sees Serpico, that's the office that I was chief appellate attorney and counsel. Then I got an offer to go into private practice with my former partner, Barry Slotnick, with whom I tried the Bernard Goetz case in the late 80s. And I've been where I am now with my friend Ben Brafman as appellate counsel since 1994. I have briefed and argued scores of appeals in the appellate division and in the New York Court of Appeals. The appellate division, so you know, let me give you a quick primer on New York procedure. There are 62 counties in the state of New York. They are divided into 4 departments of the appellate division. The appellate division first department, which Bronx and New York County are part of, sits on 25th Street and Madison Avenue. They get appeals from trials, felony convictions in Bronx and Manhattan. The second department covers all of Long Island, Staten Island, Rockland, Dutchess, Westchester, all the southern tier of New York. Appeals go there. There's a third department is Albany, and the fourth department sits in Rochester for the northwest counties. After that, it goes to the state's highest court. You get an appeal as of right to the appellate division. You want to go to the state's highest court in Albany, where I've now appeared. This was my 25th time. That's by permission. I will get into that in a little more depth later on. To me, because I'm a post-conviction lawyer, my idea of taking a client to lunch is putting coins in a vending machine in a correctional institution. And I've been in about 30 of them around the country over the years, federal and state. The direct appeal that I've talked about are the ones that go to the appellate division and then by permission to the Court of Appeals. There's also what's called a collateral challenge to a conviction. That's where the record is not sufficient. You know, you'd see on the TV a stenographer taking everything down. That's vital, because that's what the appeal is premised on. Everything that happens in a courtroom is reviewed. If the attorney does not object, and you always wonder why an attorney objects, because if he doesn't object, it's called not preserved, and the appellate court will not review the issue that I would raise as appellate counsel. So a collateral challenge under the Criminal Procedure Law section 440.10 sub 1 is where you can argue that newly discovered evidence has come to the fore since trial. You've determined that there's been prejudicial prosecutorial misconduct, or anything that's not reflected in the record. That goes back to the trial judge. The trial judge may or may not conduct a hearing. That hearing creates a new record, and that you can try to appeal as well. You also have to raise federal issues under the Constitution if you want to ultimately go to federal court, federal habeas corpus, after your state appellate process has been exhausted. But let's concentrate on the claim of actual innocence, because that's what this is all about. As I said, I won 95% of my cases as a prosecutor. I thought I was brilliant. I really thought I was Clarence Darrow and reincarnate. Then I became a defense lawyer and won 5% of my cases. And then I realized, whoa, the cards are really stacked against you when you're a defense attorney. But now I'm up to about 25, 30%. So I think that's pretty good, given the statistical norm. Of those victories, a lot of them and most of them result in new trials. You raise errors of law in the introduction of evidence, errors given to the jury by the judge in the instructions, prosecutorial misconduct. That gets you a new trial. That doesn't vindicate you. I have had the pure zechut, the joy, utter joy, of walking 4 people out of prison after demonstrating their innocence, both either on direct appeal or on this collateral challenge that I talked about a moment ago. I'm now working for the last 7 years on a case in Queens County, which is the bane of my existence, Queens County, on a shaken baby case where I'm in the process of demonstrating the innocence of this defendant, and I hope to be successful in that effort. And that's pro bono. I'm reserving my special place in Shemayim with that particular case. A jury, by the way, is instructed to find either reasonable and articulable doubts. If you may think he's guilty, you may feel he's guilty, unless you can have a doubt, you can actually enunciate and articulate and explain. You have to, with that doubt, you must acquit. So while like somebody like Anthony, who you'll hear later, has been acquitted, his odyssey is not over. To vindicate himself in civil court and get recompense for 20 years of incarceration, we must now go into civil court and bring several lawsuits where we have a clear and convincing burden to demonstrate his actual innocence. We believe we did it at the trial, but we hope to do it again, and hopefully we'll even have a settlement because the Attorney General ultimately will not want to put themselves through that. So I want to discuss 3 of those cases, including, obviously, Anthony's. Bless you. Richard Chilingarian. Name doesn't mean anything to anybody. In 1990, Richard Chilingarian was convicted after trial of the attempted rape of a teenager on a Queen Street at 2 o'clock in the morning. The perpetrator of the attempted rape was described as a white male, 5 foot 10 inches tall. Richard, 6 foot 4. He's picked out of a mug book. Why? Because he had a counterfeiting arrest, which ultimately was dismissed years before. It should have been sealed, but it was not. His picture was in a then mug book. Now it's done digitally, but this was 1990. The detective, who then went to pick him up and now had to put him in a lineup, sees this tall guy and says to himself, oh my God, what am I going to do? She's never going to pick him up out of a lineup, and then he's going to have a non-ID. That'll create a reasonable doubt. No one will ever get convicted in this case. So what does the detective do? He puts Richard in a sit-down lineup with fillers all sitting next to him. Fillers are the police or whoever's hanging around the precinct they throw into a lineup that has a similar physical characteristic. But by sitting, he evened the playing, and it was very similar to his mugshot, and the complainant picked him out. Richard turned down a misdemeanor plea. The people knew they had a weak case based upon his size versus the description. They offered him a misdemeanor with no time. Richard turned it down. He didn't want to be labeled a sex offender, and he was innocent and was not going to plead. At trial, 6 of his friends all thought they were cool because the fact of the matter is they were somewhere else, all of them. They were at a club at 2 o'clock in the morning on 12th Avenue and 55th Street in Manhattan. So they went in there. The trial attorney didn't prepare them at all. He knew what they were going to say, didn't even speak to them before, put them on the stand, 5, 6 wise guys who didn't take it seriously. The jury thought they were arrogant and disbelieved them. Richard was convicted, and he was sentenced to 6 to 18 years in prison. So, slam dunk for the DA, right? Richard brought a CPL 440 motion to challenge collaterally the conviction, and they gave names of additional alibi witnesses they had found. The judge denies it and orders the conviction to stay intact. I'm watching this story on television because a CBS reporter, Mike Taibbi, decided to make a wrong man conviction story. This is somewhere in 1990, late 1990. And I'm listening to this and saying, who represented this guy? Somebody didn't do his job. And the judge, who's interviewed by the reporter, says, I think he was guilty. That I've never seen before. A judge giving an opinion about a case, telling him he thought he was guilty. The next day, Richard's parents walk into my office. The sweetest Armenian couple you'd ever want to meet. We have no money left, but you need to help us. I say, excuse me? I look up, am I on candid camera? I just read about this case, saw it on TV, I saw it last night. They have no money, and they want me to help them. I don't know what I'm going to do. He had a 440 denied. He had a conviction. It was upheld on appeal. Let me read to you what the appellate division said. The defendant further contends, this is the court that upheld his conviction, the appellate division, 2nd Department from Queens County. The defendant further contends that his guilt was not proven beyond a reasonable doubt in view of the several inconsistencies between the identification testimony of the two main prosecution witnesses and his appearance on the night of the crime, and given the alimony testimony proffered by the defense. However, resolution of issues of credibility, as well as the weight to be accorded to the evidence presented, are primarily questions to be determined by the jury, which saw and heard the witnesses. Its determination should be accorded great weight on appeal and should not be disturbed unless clearly unsupported by the record. Translation, you had your trial, you put on your alibi witnesses, the complainant said what she had to say, the jury convicted you, who are we to overturn a jury finding? Richard stayed in prison. So I discussed it with my partner, and I said, I feel a moral imperative. This offends my sense of justice. We need to do this. So I contacted the TV reporter, Mike Taibbi. I asked him for some of his leads, which he shared with me. I find 2 alibi witnesses. Could have been easy. And I had to get past the requirement, which I'll talk about a little later, about what due diligence is, because you have to demonstrate not only new evidence, but that it couldn't have been found even with due diligence at the time of the trial, which it could have been. Richard told me that he got in a fight with a bouncer at the nightclub at 2 o'clock in the morning at the time of the alleged rape in Queens, and the guy was his size, which is huge. A guy named Frank Pagnanello. He's not at that club anymore, which I now go to myself because there's no money for an investigator, so I'm doing gumshoeing, walking all over the city. 5th club I found him. He bounced from club to club. The bouncer was bouncing from club to club to club. So I said, let me ask you a question, Frank. There was this club, and I can't remember the name of it. I remembered it then, I can't remember it now. 12th Avenue and 55th Street. You got in a fight with a guy at 2 o'clock in the morning who was arrogant on the line. Oh, I remember him. You do? Oh, yeah. Would you remember the date and the time? Sure do. It was my first day on the job. Oh, yeah, and how about the time? Well, I just started. It was 2 in the morning. So you were in a fight with this guy at 2 in the morning on that night? Yes. He gives me an affidavit to that effect. Richard said that there was a place called Car Cash right next door. I think it's still there, actually, 55th between 11th and 12th. There was a black kid who was getting hassled by some guys that were passing by. He jumped off the line, pulled them off him, and the kid was very grateful. I find the kid. I said, do you remember Some big guy pulling some people off you who were hassling? Yep, I sure do. That guy was my lifesaver. Oh, really? Would you give me an affidavit? Do you know the date it was? Sure do. And what about the time? Well, I was just getting off work. It was 2 in the morning. Okay, affidavits. I put together the motion for leave to renew the original motion that was denied by the judge earlier. I approached the district attorney, and I got the judge on the phone. I said, here's my offer. I want to bring Mr. Chilingarian down from prison. You'll sign an order, Judge, writing him down. And I'm going to put him in 2 separate polygraph tests. I know that's not admissible. But if he passes both tests, I just want you to give me a hearing. Let me put my witnesses on the stand, and Judge, you'd make a determination. Now remember, this is a judge who said on TV that my guy was guilty. The judge and the DA agreed. I had not polygraphed this kid before, so this was a gamble. I said if he fails one test, I will withdraw the motion and I'll leave you people alone. I brought him down, 2 separate nationally prominent polygraphers, each passed him. He didn't do this. A month goes by, no hearing. I call up Mike Taibbi. Could you do me a favor? Call the judge who you interviewed. Ask him when the hearing is, because you understand that Chilingarian passed both polygraphs. I get a call half hour later from the judge. I never get calls from judges. I get calls from law clerks. The judge. All right, the hearing's starting a week from Monday. Okay, I'll be there. Here, I'll sign a writ. You bring the guy down. Fine. I put the people on. Each one says, that guy was with me at 2 o'clock in the morning in New York. Now remember, judges, especially judges in Queens County, they have an institutional bias against undoing convictions. So sometimes you got to push the envelope. After this hearing, the judge is still not sure what to do. I said, and now I'm really starting to burn. I think I've mellowed a little over the years, but I almost got myself incarcerated that day. Here's 2 pages of I actually found the record from 1991. The court, counsel, are you saying that the court should disregard the Court of Appeals ruling on what is required to set aside the verdict? Is that what you're saying? There were 6 elements to a motion for vacate based on newly discovered evidence, which I'll get into in a little bit. Mr. Baker, I've addressed every point, Judge. I don't know how you can make that statement. The court, all you're doing is giving me opinions. Mr. Baker, I have given you, the court interrupting, what you think of what the truth is in this case. You're not addressing the 6 points that the prosecutor did. Mr. Baker, Judge, I wasn't talking to myself just now. I was talking to the court, and I talked about 6 elements. Mr. Aloys, the prosecutor, who's now a judge, is sitting here, who I've appeared before on a subsequent case, by the way, and giving testimony about a trial, about events that he never saw. He's telling you how it all happened. I addressed each of these 6 points, and I told you what the evidence showed. If the court wants to ignore that because the court is weighted to an opinion that it gave on television, I can't help that. But the fact of the matter is, court interrupting counsel, I think you better withdraw that statement that you just made. Mr. Baker, I'm sorry, Judge. I'm angry too. The court, I'm not angry. Mr. Baker, well, I am, because I've addressed the law and I've addressed the court interrupting. You haven't addressed the law. You haven't gone over the issues. You've gone over your opinions to this testimony. It is clear that we satisfied them all. Thank you very much. So, the judge ordered a cooling off period at that moment, came back and said decision reserved. I don't hear from him for a month, 2 months. I call up Mike Taibbi. Do me a favor. Call the judge. See what's going on. I get a call from the judge a half hour later. The judge calls me again. All right, I have a decision. Bring your guy down. How'd you bring him down? I said, do me a favor, Judge. It's very, very difficult to be transported from state prison to Rikers Island and then back to Queens and then back to Rikers and back. If you're going to deny this motion, I'll waive his appearance. Just say it on the record. Judge says to me, just bring him down. Kind of knew what was happening at that point. It is now December 24th, 1991. We're in court. The judge orders the conviction to be vacated. Richard is now in the Queen's House of Detention. Right, he's sent back there for processing to be released. 1 hour goes by, 2 hours go by, 3 hours go by. I called the judge. Well, you vacated the conviction, but they're not listening to your corrections. So the judge says, come on up. I'm sitting with the judge now at his desk for the next 2 hours making calls to all the people in corrections around the city. The judge finally got his way. At 10 p.m., Christmas Eve, Richard walks out of jail with his family there. I have the clip, videotape of the newscast with the reporter saying, even counsel was crying. Hell, I was crying heavier than everybody else. I gave his son back to his mother, and the Armenian community of Bayside, Queens, gave me a testimonial dinner. 200 people showed up. Has a bad ending. Richard was dead within a year. While he had been in prison, he was gang raped and became HIV positive, suffered complications of pneumonia. But as his mother said to me at the funeral, hugging me, holding me, my son died in my arms. That at least you gave me. So, you can't put a price on that. Mike Nisto, what did I drop? Excuse me. A direct appeal to the appellate division for Mike Nisto. This was an appeal from a judgment of conviction of murder in the second degree, serving a 25-year to life term of imprisonment. He was a club owner of an after-hours club in Queens. Oh, it's Queens County again. He was said to have ordered a bouncer to take out an obstreperous patron, take him out, as the DA would argue, meaning have him killed. I analyzed a 200-page trial, and I put together a brief arguing that the testimony was unworthy of belief. The appellate division, the first intermediate court, has a unique power. Unlike the Court of Appeals in Albany, which can only pass upon preserved questions of law, the appellate division has the power to act as a second jury and undo a conviction because the verdict is against the weight of the evidence. You don't have to preserve that. That's a power that you raise in the appellate division when you write the brief and submit it to the court, which I did. I argued that I took each witness's testimony, showed how they were inherently self-contradictory and how they stepped over each other's toes, and that the result was a clear, reasonable doubt as to the veracity of any one of them, and therefore the conviction should be vacated based on the evidence. And when you win that kind of issue, you get a dismissed indictment in the end of the case. You don't just get a new trial. So, the appellate division reversed the conviction, dismissed the indictment. The testimony of these prosecution witnesses, according to the court, was so contradictory and was so inconsistent with the police testimony and other evidence in so many key respects that I could not credibly support the defendant's conviction of murder in the second degree. Accordingly, we reversed the conviction as against the weight of the evidence, and we dismissed the indictment. Mike is up in Greenhaven State Prison. It's about an hour and a half upstate. I send the order to the clerk of the court, and I said I'll get a certified order. I had to send it by email, but I get a certified order to bring up the next day. It was a Friday morning, to get him released, because I have to have the seal of the appellate division court on it. I just wanted them to know it was coming so we could avoid some delay. So I go up with 15 members of his family, his wife, his 2 small children, his brothers, his sisters, his cousins, his aunts, his uncles. And we're all sitting in the waiting room at Greenhaven State Prison for Mike to be released. We're there at 8 o'clock in the morning. 5 hours. We wait. 5 hours. They knew. They don't like to release people from prison, as Anthony and Jeff will tell you. They just were keeping him there, lahachlis, dafka. They weren't letting him out. Finally comes out with a correction officer, says, I don't want any pictures taken. No pictures, no photos. I said, well, he wanted to take a picture in front of the Greenhaven Stein with me. Nope. You got to go out on the road. Okay. Now, Greenhaven State Prison is off a highway. You have to get off the highway, which is 60 miles an hour. You have this little road, a big traffic circle, and then the administrative building. So I figured, okay, we'll go on the little road. So I tell the family, you get in the car, Mike and I will walk over there, and we'll take a picture on the road, with his daughter taking the picture. The daughter's starting to snap the picture, and I hear a guy screaming, coming out of the administrative building, running across the traffic circle. It's the cop, it's the CO, correction officer, who was bringing him down and instructed us where to take the picture. Give me that effing phone, give me that effing phone. I said, Mike, get in the car, get the heck out of here. I'll deal with this. Comes over to me and says, I told you on the road. I said, you want me to go on the road with 60 miles an hour? This is the road you meant. No, I meant that road. So you wanted me to photograph him with trucks going by. That's right. Give me the phone. I said, you're not getting the phone. I said, give me the phone. I said, do me a favor, get your commanding officer here. CO comes out, 5-10 minutes later. What's the trouble? I said, come here. I put my arm around him. I said, you see this face? Do I look like an idiot? The guy told me not to photograph him where he didn't want me to photograph, so I didn't. He tells me on the road. I just got a conviction reversed in the appellate division. I'm not stupid. I did what I thought he asked me to do. Now he wants my phone. My life is my phone. He's not getting it. So he says, come here, counselor. He puts his arm around me now. I'm walking away from the other guy. He says, I got to live with this jerk. You don't. What are we going to do here? I said, tell you what. How about I just delete the 2 photos, all right? Sounds good to me. That's what I did. This is what I had to do. This is what I had, the aggravation when you walk a guy out of prison. But the fact of the matter is, I did walk him out of prison, and it was the 3rd person that I did that for, and he tells me to this day that I'm his hero. And I can't tell you what that does for my own state of being. Okay, let's talk about Anthony DiPippo. What? Are we going to have questions later? Maybe. Yes, you can get your $5 back. God bless you. I love you, Uncle Murray. All right. Anthony DiPippo. This was a direct appeal to the Court of Appeals. I'll get to how we got there. The crime, horrible. 12-year-old Josette Wright, a resident of Carmel, New York in Putnam County, had been missing since the late evening morning hours of October 3rd, 1994 into October 4th. For 13 months, the case was investigated as a missing person case by the Putnam County Sheriff's Department. On November 22nd, 1995, a hunter walking in the woods above Fields Lane in Carmel, New York, kicked over something, picked it up, saw it was a human skull. Calls up the authorities. Ultimately, they come there, and the skull is where it was. They look around. 25 feet from that point, they find the skeletal remains of someone ultimately who was identified as Josette Wright. Forensic findings. At the top of her spine, where the skull used to be but is no longer, near the neck, were found a pair of blue panties. The jawbone, or mandible, the lower jawbone, was found nearby with a bra tied around it with some hair caught in it. According to later analysis by a biological anthropologist, way later, I'll explain why that's important later, the hands are found to have been restrained, tied from the ankles up to the wrist, in the back, around the neck, and back down the feet. This was described as a hog tying, where it makes the body more compact for carrying, and it causes maximum pain to the victim because anytime there's a movement, the knots get tighter. On first appearance, because the body was faced down and it completely had decomposed, and the hands had basically fallen through the rib cage, it looked like the hands were actually tied in front. This becomes important. The remains were forensically identified to be that of Josette Wright, but no cause of death could be ascribed. This investigation conducted by Deputy Sheriffs Patrick Castaldo and William Quick, and supervised by Dan Stevens, good friend of Jeff Deskovic, who used to be a Peekskill police officer, who took his false confession before he moved to Putnam County, and you'll hear about that. And the testimony of Denise Rose, the only witness who implicated Anthony and Andrew Krivik in a separate trial. They were convicted of the rape and murder of this 12-year-old girl and sentenced to 25 years to life. Rose had denied any knowledge of this event for 18 months. She testified that she had been picked up in a van that Krivik was driving, and in that van were Anthony and Andrew, both huge guys, as you'll see, and two other guys, Adam Wilson and Bill McGregor, she and Josette. 6 people in the back of a van, according to her testimony. The car then parked on Fields Lane in the pitch dark and adjacent to a heavily wooded area. She swore that Anthony and Andrew had taken turns raping the girl, and that in conformity to some extent with the forensic evidence, that Andrew had taken her panties off, put them in her mouth, tied the bra around her face in order to ensure it didn't come out, and that she suffocated and became unconscious in the course of 2 rapes because Anthony was supposedly followed Andrew. According to Rose, she was threatened by Anthony. The same thing will happen to you if you tell anybody. The conviction was later upheld on appeal. But in a continuing, and I have to say, extraordinarily indefatigable effort by Anthony to demonstrate his innocence, with different attorneys, he brought several motions to vacate the judgment, collateral motions to the trial judge, based upon new evidence here and there. In his 4th attempt, on appeal to the appellate division by permission, the court ordered a second trial. They found that evidence had been presented by the defendant in the motion to demonstrate the guilt of a third party, someone named Howard Gombert, and who was a serial rapist who was at the time incarcerated in Connecticut, and who was by then serving a 30-year term of imprisonment in that state. The court held that a new trial was required because Anthony's lawyer at the first trial was also Howard Gombert's lawyer. You can't have a more blatant actual conflict of interest as an attorney than that. How do you represent a guy who is trying to implicate your other client without compromising your other client's privileged conversations in behalf of the first guy? It's undoable. So the court granted a new trial. The second trial. At the second trial, the defense offered evidence of a jailhouse confession that Gombert made to another inmate, a fellow named Joseph Santoro. This is a very complex case, so you really got to pay attention to this. It's very prolix. This is from Hashamayim. Joseph Santoro was an inmate in Connecticut where Howard Gombert was incarcerated. Joseph Santoro came from Carmel, Putnam County. He knew about the Josette Wright case. He knew about Anthony DiPippo because it was the most notorious case in the history of the county. It was saturated across the media for years. He's in the shower, Gombert's in the shower, and he hears somebody talking about the crime in Putnam County. He listens more attentively, and he hears the guy basically admitting to having committed it. He goes back to his cell that night, takes a lot of notes, and just puts them away. Never knowing what to do with them, but something compelled him to do it. He's then finishing his Connecticut sentence and is brought back to New York, and he's in a way station in the Putnam County Jail. Anthony DiPippo is now back in the Putnam County Jail from upstate prison because he's facing a second trial. Santoro sees Anthony's name tag. Anthony had brought him food as a newcomer. He was trying to be nice and neighborly to a newly arrived inmate because that's who Anthony is. And he says, "You're Anthony DiPippo. I got something for you." He gives him his notes, demonstrating the confession, essentially, by Howard Gombert in Connecticut. This is offered to the judge at the second trial, as is evidence of 6 women who, as young girls, were raped by Howard Gombert, also restrained, also with clothes in their mouths, also near woods, and the judge denied all this evidence. He denied it, even though the appellate division sent it back for evidence of this very conflict, of the implication of Howard Gombert. In a lengthy series of rulings, he determined that the proffer did not satisfy the rules of evidence. Anthony was again convicted upon the testimony of Denise Rose, and again sentenced 25 to life, sent back to state prison. Anthony's stepdad, who, in my opinion, most incredible and devoted stepdad or dad in the history of the world, had the perspicacity to visit my partner Ben Brafman and me, and ultimately hire me to do this appeal. After I read and digested the huge record, another 2,000 pages, including the necessary portions of the first trial, I go up to visit Anthony in prison, and we map out our appellate strategy. And I said, I think the appellate division just missed the boat. The trial judge just missed the boat. So without elaborating on other points I raised in the brief, because there were other errors of law that I had litigated as well, I argued to the appellate division that the trial court had misapplied the rules of evidence. I coined the term, and we argued that the court in doing so had destroyed his federal constitutional rights to present the defense under the Sixth Amendment. Had to raise that federal constitutional issue in order to ultimately exhaust state remedies if I have to go to federal court if we were not to be successful in the state appeal. So I argue that there was a reverse Molyneux error by the trial judge, and that the declaration against penal interest of Howard Gombert was improperly precluded. Now, what does that mean? There's a rule of evidence in New York from 1901 on the books called People versus Molyneux, on the federal rules of evidence 404B, it's the same thing in federal court, where evidence of prior acts of uncharged misconduct are able to be introduced at a trial in order to show motive, identity, absence of mistake, intent, or a common scheme or plan, to show if there's any doubt about the culpability of the person on trial. So I argued, and this was the first time this was raised in an appellate court, why can't a defendant do the same thing about a third party he's trying to implicate? We should be able to show that these 6 women, under certain similar circumstances, were raped by this guy, to show his identity in this case, and that there was a common pattern of conduct, a signature to his crime to show his identity. A declaration against penal interest. What is that? And this is what I claim Gombert had given. A statement may be admitted as a declaration against penal interest where the declarant is unavailable at trial as a witness. The declarant was aware the statement was against his or her penal interest when it was made. The declarant had competent knowledge of the facts underlying the statement, and, most important, in this case, supporting circumstances independent of the statement itself attest to its trustworthiness and reliability. So, those are the arguments we made. Much to our disappointment, the appellate division upheld the conviction. Now, that was appeal as of right. I then had to move for permission to appeal to the state's Court of Appeals. You get a 2% chance. They get about 3,000 applications a year. They maybe take 200, less than that. What happens is a criminal leave application. There are 7 judges that sit on the state's highest court. You write to the chief judge. You raise the issue of why it's worthy of the Court of Appeals considering it, because there's never been passed upon by the highest court. It's a new area of law, or there's a conflict among or between different departments of the appellate division. It's assigned to then Judge Robert Smith, who's since retired. I submit amplified remarks to him, and we meet in chambers with the DA in Manhattan and discuss. Right before Christmas in 2015, I get an order granting leave. I call up the DiPippo family. I said, this is it. We got a 50-50% chance now because the court took the case. While this is happening, I get a call from the Attorney General's office, Assistant Attorney General in charge of the Conviction Integrity Bureau. Come on down, we want you to meet with me and Adam Levy. Adam Levy is the district attorney then of Putnam County, who convicted Mr. DiPippo. Okay, I'll come. I go there. Adam Levy had just indicted Patrick Castaldo for offering a false instrument for filing. Patrick Castaldo was the lead investigator in Anthony's case. Subplot. You can't make this stuff up. This is a movie, Anthony. Castaldo is the deputy of the sheriff in Putnam County with whom D.A. Levy is having a feud, and they're suing each other for this or that in civil court. They hate each other. So now Levy, who convicted DiPippo, wants to undo the conviction because he wants to embarrass Castaldo and Smith, the sheriff. I'm all for it. I said, I understand we all have different agendas here, but, the end is the same. So he gives me, while I'm there, he shows me a videotape where a guy named Scott Oliveri has, in a van, Adam Wilson, trying at Castaldo's behest to get Adam Wilson to again recant his recantation. What happened originally was Castaldo got Adam Wilson to implicate Anthony. But Adam Wilson, once he was out of Castaldo's clutches, said, I lied. These guys were scaring the heck out of me. I wasn't with Anthony. So Castaldo is trying to get Oliveri with Scott, Adam Wilson in a van to again implicate Anthony, and he's saying on videotape, that's ridiculous, want me to lie, I'm not going to lie, I was not in the van, I don't know anything about this, and I'm not going to do it. And this is when he doesn't even know he's being recorded. So that is what's called Brady material. Brady material, Brady versus Maryland, Supreme Court of the United States, when a prosecutor is in possession of evidence that would tend to exculpate the defendant, it is imperative, it's a constitutional imperative, that the DA gives that over to defense counsel, because we don't play games, and at least we're not supposed to play games. I have more Brady violations than I can count in the last 33 years, but this was blatant. The DA and the AG say they're continuing their investigations, including they're going to go visit Denise Rose. Meanwhile, my briefs are due in the Court of Appeals, so I prepared that, and they're filed. And I continued to work on that, and that was filed in March 2015. At the same time, I'm in communication with the DA's office. He assigns an assistant to work with me. I draft a motion to vacate judgment based upon the material he gave me. They vet it. I submit it to them, the draft. The idea is Levy will consent to a hearing where we can put Castaldo on the stand, barbecue him on cross-examination, and introduce all this evidence that had been withheld to me to show that they manufactured this case against Anthony. Problem is that in November of 2015, Levy's defeated as district attorney. A guy named Robert Tendy is now elected, who's a pretty nice guy. The assistant attorney general and I have become very friendly at this point, make an appointment to go see him sometime in December. He wasn't going to be sworn in until January. I said, here's the deal. The plot thickens. Who's the new DA's best friend? The sheriff of Putnam County. So he's not about to want to embarrass him. So I said, here's my suggestion. I know you and he are good buddies. I gave him the motion to read. He saw what I was going to say and do about Castaldo. Let's do the Court of Appeals argument where you're going to oppose me, and if I lose, I come back to you, try to convince you to consent to a hearing like Levy was going to do. If I win, academic, we're getting a new trial. So he agrees to wait that out. He was very relieved I wasn't following that motion because it would have embarrassed the sheriff of Putnam County. Okay, we argue this case on January 7th, 2016, a little over a year ago. Again, it's my 25th appearance in the state's highest court. Not too many lawyers have been up there that long, and it's just something I really enjoy. 7 judges throwing questions at you from the entire bench, and you have to respond with legally correct answers to what they're asking, and you have to literally convince them to give a guy a new chance at a trial. March 29th, 2016, Court of Appeals decision comes in, reversal. This is what they wrote, in part. Viewed in its totality, if proved through appropriate witness testimony at trial, defendant's proffer demonstrated that Gombert knew and had access to the victim. He was familiar with the road near which the victim's remains were found. He had a history of allegedly assaulting other young girls with whom he was familiar in a manner uniquely similar to the prosecution's theory of how the victim was killed, and that Gombert allegedly made statements indicating they had sexually abused the victim around the time of her disappearance, and that defendant and Krivik were prosecuted for crimes that he had committed. And so they decide, yes, there is such a thing as reverse Molyneux, and the defendant has a right to present that evidence, and the declaration against penal interest was independently proved to be trustworthy, and it should have been allowed to be introduced at trial. So we have a third trial. Now, you should know, a defense attorney is only as good as he has an extraordinary investigator. And we had 3 of them. We had Lou Morgan. Is Lou still here? And we had Trey Bondi. And we had Ralph Jones. And there is nothing they couldn't find that we asked them to find. They just pilloried us with evidence upon evidence and spoken to witnesses that we needed to speak to and got them and brought them down. And it was an incredible effort on their part, made our job that much easier. I talked to Robert Tendy. I meet with him, try to convince him to drop the case. No. He can't. I mean, he's a newly elected DA. He's the most notorious homicide in the history of Putnam County. He would have been run out of town if he would have caved in, so he had to try it. As I said, I'm not a trial lawyer. I'm an appellate lawyer. So we brought in one of my partners, Mark Agnifilo, who was supposed to be here tonight but had a family matter in camp, and he was going to give you the rest of what I'm about to tell you. He's a phenomenal trial litigator, and I became legal counsel. What does that mean? His job was to get an acquittal. My job was to anticipate a conviction and to preserve the record for appellate review in the event there was such a conviction. So I couldn't be given the argument by the DA. There was no objection. There was no offer of proof. It's not preserved for appeal. So that was my job. Following extensive pretrial hearings starting in August, the judge determined and whittled down our offer of 6 women to 3 women who would testify to prior similar acts of Howard Gombert, and there was no question that Santoro was going to testify, although the DA wanted to get part of his statement out. We weren't going to allow that, and the judge ultimately agreed with us. And I'll read that statement to you in a minute. The crime scene, the van. Among other points, we proved that the van was not operational in the fall of 1994 when this was supposedly happening. We proved that the side door was not functional. It would have fallen off if you tried to open it. That's the one that Denise Rose said that they had all entered and exited the vehicle from. When Krivik had been arrested on drug charges in May of 1995, Andrew Krivik, in his van, and his van was impounded, and there was a search of the van, and what's called an inventory search. You bring the van into the police premises, and you quickly determine to safeguard. The purpose is to safeguard, but it's actually a search, although it's more cursory. According to the report, the van then had 2 seats, front 2 seats. The back 2 seats were gone. That would leave more room in the van. On the other hand, at the behest of our good friend Patrick Castaldo, it's probably the only honest thing he did in the case, although it wasn't him who did the search, it was searched again in January of 1996, and lo and behold, there's 4 seats in the van. Now, certainly in all that time that the van was in police custody, nobody bothered to put 2 seats in it. They were always there. But what does that do? It makes the back of the van that much smaller, where not one person, let alone 6 people, certainly the size of Anthony and Andrew, could have fit. We stressed that the van had a very shaggy carpet, and that they did forensic vacuuming and a special light to locate blood, hair, and semen, and that despite all that was alleged, despite all the struggle that was alleged, not an ounce of DNA evidence was found. So the argument was the absence of evidence is evidence of absence. And we also noted the van had never been cleaned, so it couldn't have been wiped of any DNA, because they all said it was filthy, all the cops testified. Denise Rose's credibility, obviously that's something we have to deal with. I could spend 2 hours alone on what we did on cross-examination, or what Mark did on cross-examination, to challenge her credibility. Suffice it to say that the Assistant Attorney General and D.A. Levy, after interviewing her in Florida in preparation for this trial, disbelieved everything she said. They don't believe she was ever in a situation to implicate anybody for raping Josette Wright. We emphasize that Josette Wright had admitted to being a crack addict back then, in her words, 1,000 times she took it, and that for 18 months following the missing person report of Josette Wright, Denise Rose continually denied any knowledge of whereabouts. It was only after she had been threatened with 25 years to life incarceration that as a conspirator in Josette Wright's murder, that she agreed to implicate DiPippo and Krivik. Now, Castaldo had made a simple mistake. Remember, I told you that when the body was first found, it appeared that the hands were in front. So Denise Rose had continually testified, first trial, second trial, that the hands were tied in front. She was locked into that testimony and testified that the hands were tied in front in the van by Andrew Krivik. The problem is they had to also call their forensic anthropologist, who testified, no, the hands were tied in the back. They were hog-tied, as described, and therefore Denise Rose's story started to unravel just by that fact alone. She was locked into that story. She had to testify again. We also established how she was unable to explain how after she was dropped off that night, she didn't even call 911 anonymously, maybe send some cops over to Field Lane to help some girl who didn't get brought back to the car because she didn't know she was dead. And that she spent the next 18 months, Denise Rose, who implicated Anthony, spent the next 18 months partying, drug shopping. Anthony had a few peccadillos back then. Going to rave parties and even having a romantic relationship with Anthony DiPippo following this event, this horrific event. In fact, the next day, October 4th, Castaldo gave her the way to remember the date because her other friend was getting out of jail that day, and they were picking him up. And then where did she say she went to hang out the entire day? Anthony DiPippo's house. This is after watching him involved in the brutal rape and murder, supposedly, of a 12-year-old girl less than 12 hours before. We called two witnesses who our crack investigators found for us again, Allison Clokey and Lorraine McLaughlin. Allison Clokey was a friend of Josette Wright. She testified, and she wasn't put on the stand at the second trial because the attorneys were afraid that she had given inconsistent statements, that on October, 4 days after October 3rd, when she was supposedly raped and killed, Josette Wright was seen by Allison, excuse me, I was right the first time, with a bunch of boys, and they talked for a few minutes, and then she disappeared. Castaldo and his confrere Quick earlier had tried to confuse her at earlier trials by suggesting it wasn't October 7th, it was really September 3rd, because her reason of remembering was that she had been at that mall to pick up her prescription glasses. They tried to convince her she really meant September 30th, which would have been a poor October 3rd. The problem is, she gave this statement to the missing person investigators 4 days after she said she saw her. So her memory was a lot better then. And it was another example of Castaldo trying to trip up a witness. And she had no agenda to help Anthony DiPippo. None whatsoever. She's a friend of Josette Wright. Lorraine McLaughlin. When I read the trial after the second trial, this was my favorite witness. This was Josette Wright's teacher. She testified. And a lovely woman. Lovely woman. I would buy a used car from her without even taking it around the block. She testified that October 8th, a day later, and she remembers it because it was Columbus Day weekend, she was in the Poughkeepsie Mall and ran into Josette Wright. Now it's 5 days after she was supposedly raped and killed. And Josette was with one of her friends, and Josette Wright introduced her to her friend as her teacher. Now, what did Castaldo and Quick do with this before the second trial? They said to Lorraine, you had to be wrong because you were probably thinking of the Jewish holidays. And she didn't have a calendar with her at the time. And so she took their word for it. She probably made a mistake and signed a second statement. But then she looked at the calendar. The Jewish holidays were beginning of September in 1994. She knows this was Columbus Day weekend. So she changed her testimony again. And because of that, the jury at the second trial didn't believe her. We laid this all out before this third jury, all the shenanigans of Castaldo and Quick in trying to get her to change her testimony. And she said she knows this was Columbus Day. She knows. And in fact, at the second trial, when she was at the second trial ready to appear, she wasn't called the first day. When she drove home to her sister's house, or her friend's house, she was followed by 2 or 3 deputy sheriffs who stopped her when she got out of her car in the driveway, tried to convince her again that her anticipated testimony at the second trial was wrong, and that it was really the Jewish holidays that year. So this is another example of our demonstrating how the investigator was trying to create a case out of whole cloth. The Santoro testimony. Remember, he's the inmate that was with Gombert in Connecticut. So what's his statement? He wrote it down. I'll read it to you. I've cleaned it up a little bit. A lot of expletive deleted. So Santoro said to Gombert, it really doesn't matter if they got him for the 2 murders in Putnam County because he's doing 30 years anyway. Gombert laughed and said, they ain't got expletive on me. He said, they are trying to get me for killing this girl, Josette, but that they already convicted some other suckers. So I said, Santoro, so the other guys didn't do it? He laughed and said, even if they didn't, they got no evidence against me. It's been a long time since then. He said, Josette was nothing but a little slut anyway. I said, being Santoro, why? What did you do? Expletive her? He went into this whole story about how he met Josette at his girlfriend's house. He thought she was cute and that she flirted with him a lot. She even offered to babysit for him and his kid's mother. He said he had to decline at the time because his baby's mom was still with him. He also said the only way he could get her into his car was to tell her he wanted her to babysit for his daughter. He said he ended up expletive her in his red car. He said he had a red car with a black hood. I asked him if that happened around the time she died. He said, yeah, the time she disappeared. He smirked. Santoro then said to Gombert that Gombert, better not say anything about that, to which Gombert responded, it don't matter now. They already got those other guys suckers, so I'm in the clear. Gombert told Santoro that the other girl he had killed was named Robin, whose body they will never find. So this is now read to the, not read, Santoro recited it to the jury. And as I further promised the Court of Appeals we would do in order for them to require the introduction of this statement, we had to independently demonstrate its trustworthiness, separate and apart from the statement itself. So how do we do that? We proved that Gombert knew Josette Wright and had met her at his girlfriend's house, and had gotten very friendly with her when she was 11, 12 years old. We proved that in the presence of the baby's mother, a woman named Stephanie Conway, who ultimately we didn't call, but we stipulated to her what her testimony would have been, Gombert had asked Josette to actually babysit for their daughter. We proved that Gombert drove his daughter's mother's, Stephanie's, red car with a black hood with Connecticut plates. And although the proffer was limited by the new judge, because he didn't want us to go into Robin Murphy too much, we proved that another girl named Robin Murphy, the Robin he referenced, had been missing since around that time, and she has never been found. In fact, her murder was being investigated by the Carmel Police Department. And the Carmel Police Department had asked the Putnam Sheriff's Department if they had any evidence because they were looking at Gombert. And the Putnam County Sheriff concealed evidence of Gombert's involvement from the Carmel Police Department, believing that if they would come to the conclusion that Gombert was responsible for both, that would take the spotlight off Anthony and Andrew, and they didn't want to ruin their case against him. That was their priority. And then there was the reverse Molyneux evidence. The 3 girls, they were women at this point, but they each testified that when they had been 7 and 8 years old, Gombert had raped them. And Gombert had put clothes in their mouth, whether it was their panties or his own shirt, and that he had tied them and restrained them, and that one of them, or 2 of them, were actually taken into a wooded area by Gombert. We also called Adam Wilson. Remember, he's the guy in the van that wouldn't recant his recantation. Bill McGregor and Michael Moynihan, 2 of 3 said were in the van, who testified to the fact that Castaldo pressured them, coerced them, threatened them into implicating Anthony, and they stuck to their guns and said, this never happened, they were never in the van. The pièce de résistance, and the one I'm most proud of, was getting Deputy Sheriff Patrick Castaldo to have to be brought into the courtroom. The The DA was not going to call him because they knew what we were going to do to him on cross-examination. But his name was mentioned by every witness. He was central to this case. So I said to the judge, you're going to have to give a missing witness charge if they're not going to call Castaldo, which, had he denied it, would have been 0.1 on appeal. Initially, the judge was not going to do that, but then he changed his mind ultimately because he said, how can I not give that? And what would such an instruction have been? This is what a missing witness charge to the jury in this case would have been had he not been called by the DA in rebuttal after the defense's case, because he wasn't called on the DA's direct case. Ladies and gentlemen of the jury, the fact that Castaldo was not called as a witness permits, but does not require, an inference that had she been called, his or her testimony would not have supported the people's position on that issue. Before you are permitted to draw that inference, however, you must be satisfied, 1, that Castaldo has material knowledge about that issue, 2, that he is in control of the people, in that if called, he would be expected to testify favorably for the people, that his testimony would not have been merely cumulative to other testimony or other evidence in the case, and that he was available to be produced and called by the people as a witness at this trial. The judge agreed. The DA had apoplexy, jumping up and down at least 5 different times, 5 different days, arguing against this instruction. The judge ultimately said, get him here tomorrow morning. And rather than risking that instruction, he came into the court, testified to his story. I dare say Mark Agnifalo's cross-examination of Patrick Castaldo would make compelling television. He just took him apart, piece by piece. Epilogue, 2 weeks ago, Castaldo, whose indictment was dismissed, that case with the new DA in office was shipped over to Orange County because they would have had a conflict having their main investigator in the case against Anthony under indictment and by the same office. Orange County appealed the dismissal of the indictment against Castaldo. 2 weeks ago, the Appellate Division 2nd Department reinstated that indictment. He now has to face trial on his own felony charges. And we were not allowed to touch that during the trial. Had this happened 2 months earlier, it would have been something we could have, I guess, gilded the lily with. So I'm driving home. Why? Because Erev Yom Kippur, I'm a good Jewish boy in an open Orthodox synagogue, and I got to get back here for Kol Nidre. And the jury's already given 3 notes, but I got to leave. It's already, I forgot what time it was. So I'm on the Taconic Parkway, and Lou Morgan calls me. Hey, you should have heard what happened in court. What's that? Did they ask for Castaldo's readback? No. I said, what evidence do they want? They acquitted him. So, whoa, I almost drove off the highway. I started crying uncontrollably. I can't tell you, but I missed the verdict. I missed the verdict. Anthony DiPippo is now a free man. And as I said, the fight's not over. We will continue it in civil court with the hope that the powers that be, the Attorney General's office, has to defend our case against the wrongful conviction against the state, yet they got another bureau in the Attorney General's office that thinks he's innocent, so they're kind of in a precarious position. And we're also going to sue the Putnam County Sheriff's Office in federal court for violation of Anthony's civil rights. And with that, I want to bring up here somebody who served 20 years in prison for a crime he did not commit. Anthony, come up.
No, thanks to this man, this great man. It's an honor to be here. It was a no-brainer. Once he said, Anthony, will you come speak at my synagogue? There was no doubt. And I would do anything for this man. I owe him my life. Thank you so much, Mark. Thank you. I was 18 years old when this crime happened. You know, I was involved in criminal mischief. I wasn't the most honest kid, but I wasn't a real tough guy. I wasn't a bad guy. I wasn't out robbing people. I wasn't out committing murders or breaking into people's homes. And, I was doing what kids normally do. And for a couple years, I was doing that, and I became 20 years old. And at 20 years old, I went to do a 20-day violation probation in the county jail. So as I'm in the county jail, they say, Anthony DiPippo, we need you in booking. I said, what do you need me in booking for you? I don't know, go up there. So I go up there. I'm almost ready to go home. I think maybe they're going to let me out a couple days early. A detective comes over from BCI. He says, Anthony, you got to come with me. I'm not going nowhere with you. I know what you guys are up to. I'm not going with you. I said, well, you don't really have a choice in the matter. So he put handcuffs on me. And I have no idea what's going on. I think I'm going to be, interrogated for some matter. I'm brought in front of about 20 cameras and TV news media, and they say to me, how do you feel about Andrew Krivak had ratted you out? Did you kill Josette Wright? And I'm looking at these people like, are you serious? My heart's going, I'm pounding, I can't catch my breath. I think it's the end of the world. So I get to the other side, and now mind you, they do this to me 3 times. They perp walk me. They walk me into the building, only to walk me out of the building, to walk me back around in the building again, to show me off for the TV. So now I go to court, and judge said it was a heinous crime, no bail. And that was July 1st, 1996. And I embarked on a 20-year journey to vindicate myself. 3 days later, I had found out that one of the witnesses that they had against me was recanting. I didn't know who the witnesses were. It was Adam Wilson. He said he wasn't in the van. I didn't know there was a van. He said that the cops threatened him with 15 hours of interrogation. They gave him a lie detector test, who you'll hear from Jeffrey Deskovic. Same individual, Daniel Stevens, gave the lie detector test to, which preceded his false confession, which he later proved through DNA evidence was actually false. And he's here today, he's going to speak. So now I say I'm going to take a trial. I'm innocent. I didn't do this. I'm a victim here. I don't know what's going on. The jury has got to find it right. This is what the system's made for. I'm going to take a chance. So we hire a lawyer, pay him some money. He represents me. He tries the best that he can. Again, this is the same lawyer that had previously represented Howard Gombert and failed to disclose it. I'm not going to get into, the morals and ethics of what he did. I think he tried. I think that he did realize there was a conflict. So I blow trial in July 97. Now I'm going up north with the big boys. I'm scared to death. I think, everything you see on TV, I think, I'm going to get raped, I'm going to get stabbed, they're going to take my property, I'm scared to death. And I get there, and I just realize, it just seems like it's just regular guys. So I start doing my time. And then people find out why I am in jail. So now I get cast out into another type of cast, which is rapos and pedophiles and rats don't have friends. I'm not a rat. I never told on anybody in that regard. And but now I'm cast as a rapo, as a pedophile. When I go to the yard, they don't want me to use the weights. They don't want me to hang out with certain people. They want to be, they point their finger at somebody else because I guess inside it makes them feel better about themselves. So one day I just got up and said, I'm tired of being a victim. I want to be a victor. So I started going to the law library. I started learning what Mark Baker does for a living. I started to go to law library. I started to study the Supreme Court precedent. I started to study statutory law, and I started to try to apply it, to try to put this puzzle together. And thankfully, with my friend Lou Morgan, who's over there, he's been with me for 16 years. He's the longest member of my defense team. Trey, I had a good team. My family was able to piece together some things. Now Mark had mentioned the term reverse Molinoff. Now I filed 20 appeals. Many of them I filed on my own. I didn't have a lawyer. My family didn't have money. at the time. They did have money, but they didn't have money for an attorney at the time. So I picked up the sword myself. And like they said, I'm not going to be a victim anymore. I'm going to be a victor. So I tried to go into courts. I tried to get new evidence. I tried to get the investigators to go out and follow new leads. They got me the serial recantations of perjured testimony. They found the Gombert victims. And the term reverse Molinoff, as Mark had mentioned, I didn't have a term for that. I tried to go after the DNA. We found hairs in a rope. We tried to match them. We couldn't match them. So what happened was, I said, there's got to be another way to link Gombert to the rope. He's got to had done this before. So through investigation, we found a few people, certain names, and it's a shame that, you know, that we had to make these girls go through this experience, but I'm very thankful that they were cooperating, and they really saved my life. And like he said with the Attorney General, I thought that was a new hope. I didn't think that this was going to go for a new trial. We had gotten a 10th girl. He had mentioned 6, but we have estimated 10. This girl was also Gombert's babysitter. 64 days prior to when she had disappeared, she was abducted at knife point. Her hands behind her back, clothing article on her mouth. She gave a police statement that very night, and they took a DNA kit, which they had thrown out. I said to myself, I said, somebody's got to hear me now. And at this time, Marcus represent me. Marcus kind of giving me advice, let me handle it, let me handle it. He actually kept me from filing a grievance against the district attorney. Thankfully, you gave me that advice, because we would have been enemies with him. I asked the district attorney, please help me, man. I got this stuff. At least, you know, give me a shot. Let me look. Just, you know, see if we can find the DNA. If there's anything you could do. And I really didn't have no hope for this. Within 2 weeks, he gets a letter in his office. Or you got a phone call from Gail Heatherly saying that they were going to reinvestigate the case. So I run a new trial. We finally get to the new trial. And after 20 years of fighting, writing letters, I don't know, you got, what, 5 letters a day from me sometimes? You know, you got to do what you got to do. Finally, we get a reversal. Again, after a second time. I'm kind of skipping here because Jeff is going to speak in a moment. So as we're going to the trial, you know, we get all this great evidence. I get bail. The district attorney remands me for some things that I said on Facebook. So I was home for 75 days. Finally, after 20 years, I'm on television. My family, everybody's there, we're hugging, everybody's crying. I get out of jail. I make a few mistakes, which I'm not too proud of. So we go back to jail, and as we're going to the trial, I'm looking at Mark, and Mark is writing something on a piece of paper. And I said, Mark, what are you doing? He said, I'm writing your next appeal. I said, that's not too reassuring. But, you know, he said, like he said, his job was to anticipate a conviction. Mark Ignifalo's job was to get the acquittal. And it was a privilege to have known you as a man. It was a privilege to be represented by you, and I am forever grateful. And for whatever you ever need from me, I am there. It doesn't matter what it is. If you need somebody to take your dry cleaning out, I'm coming to your house. I'll do that. I do want to say one more thing. About a couple weeks ago, I ran into one of the jurors in my case. This was juror number 9. He came up, me and my mom were walking in the mall, and he introduced himself. He's smiling. I never saw him smile before, so I didn't know who this guy was. I said, I was about to ask him, what prison was I with you at? He said, no, I'm juror number 9. So he shakes my hand, and he says, you know, I'm happy you're home. Listen, I was the holdout. They were ready to acquit you 11-1, and I was the one that asked the 3 questions. He said, you know, I do believe you're innocent, and I'm really glad you're free. And his son that was with him was about 15 years old, says he wants to be a wrongful conviction lawyer. And of course, you know, I'd like to introduce Jeff to him one day. With that being said, may I? Okay.
What he's not telling you is I accomplished like a miracle. I got this guy bail on June 1st. He's out of jail. We walked him out of, that was on Channel 4 News. So what does he do? He's home learning all about Facebook, and he goes up on Denise Rose's page and says, you better tell the truth this time, or something to that effect. The DA asked to be remanded. We had a hearing with the judge. He said he's not threatening her. He's only telling her to do the right thing. Remanded. He's put back in jail for their whole trial.
In my defense, too much freedom, too fast.
Too much. You got to decompress. Jeffrey Mark Deskovic was wrongly convicted in 1990 at the age of 17 of raping, beating, and strangling Angela Correa, who was a 15-year-old high school student, classmate at Peekskill High School. On December 7th, 1990, a jury convicted him based on testimony from Peekskill Police Detective Daniel Stevens, our good friend who supervised Castaldo, that Deskovic had confessed to a crime. Deskovic proclaimed his innocence on numerous occasions after his conviction. He was repeatedly denied a reopening of the case by then District Attorney Jeanine Pirro of Fox News fame. Since at least 2000, Deskovic also appealed to DA Pirro to run DNA testing to help prove his innocence. She declined. Ultimately, it was allowed by then District Attorney Janet DeFiore, who is now the Chief Judge of the State of New York, who authorized a DNA test and led to his exoneration. The DNA from the crime scene was matched to a gentleman named Stephen Cunningham. Jeffrey Deskovic is now in law school. He's getting his law degree, God willing. He posts the time when he's taking exams on Facebook, so we could all wish him good luck. And he won a multi-million-dollar lawsuit against the Putnam County, and with that money, he founded the Jeffrey Deskovic Foundation for Justice. Jeffrey, come on up.
Good evening. Good evening. All right, great. Some energy in the room. It's great to be out. It's kind of surreal to be here. It's when you lose freedom, you appreciate the small things. So I appreciate the freedom of movement, of just meeting new people, socializing, fresh air, the sun. No oversight. I don't have to have a pass if I go someplace. So I really have that appreciation of new things, of things that most of us, including myself, took for granted, prior to my mishap in losing my freedom. So as Mark Baker mentioned, I served 16 years in prison. I was arrested when I was 16 in Peekskill, which is maybe about 40 minutes from here. I was charged with a murder and rape, which I did not commit. I turned 17 by the time the trial rolled around, and I was wrongfully convicted despite a pre-trial negative DNA test, which showed that semen found in the victim did not match me. But rather than acknowledge they made a mistake, they instead continued to prosecute me full speed ahead. The arrest and conviction was based on a coerced false confession. I was driven from Peekskill, which is in Westchester County. I was driven across county lines 40 minutes away to the town of Brewster, which is in Putnam County. So that meant that I didn't know where I was. I couldn't leave on my own. Because it was a school day, my parents thought that I was in high school, so they didn't call around looking for me. I had no attorney present. There were 3 officers present who I knew were cops from Peekskill, but then there was also Putnam County Sheriff's Investigator Daniel Stevens, who was dressed as a civilian. He was a polygraphist, and he was pretending not to be a cop, so I never knew that he was a police officer. He never read me my rights. So after giving me this manual to read about how the polygraph worked, which contained a lot of big words beyond my comprehension, they put me into a small room. And he gave me countless cups of coffee, which seems fairly clear that the purpose of giving me the coffee was to make me nervous, so that I could flunk the polygraph, because the premise of the polygraph is that if you tell a lie, then you'll become nervous, and the nervousness will result in an increased pulse rate, and it's the pulse rate which is actually measured by the machine. So after giving me 6 or 7 cups of coffee, I'm then strapped to this polygraph machine, and that's when he launched into his third-degree tactics. So he raised his voice at me, he invaded my personal space, he kept asking me the same questions over and over again. As each hour passed by, my fear increased in proportion to the time. He kept that routine up for like 6.5 to 7 hours. Towards the end of the interrogation, he said, I guess he was exasperated because he did everything but get me to falsely confess, so it's time to utilize the polygraph. So he says, what do you mean you didn't do it? You just told me through the polygraph result that you did. We just want you to verbally confirm it. So when he said that to me, it really shot my fear through the roof. And it was at that point that the officer from the Peekskill Police Department, the one who had been pretending to be my friend, whereas his partner was the bad cop. So they do the good cop, bad cop routines that when the person being questioned, you look to that friendly face for assistance. So Stevens mentions the polygraph result to me. That gets me more frightened. And then the officer comes in the room who had previously been pretending to be my friend, and he told me that the other officers were going to harm me, but that he was holding them off, but that he couldn't do so indefinitely, that I had to help myself. So considering that I had maintained my innocence for that previous 6.5 to 7 hours, it was clear what he meant by that, that they wanted me to confess. When he added that if I did as they wanted, not only would they stop what they were doing, but that I could go home afterwards, that I was not going to be arrested. So being totally overwhelmed emotionally and psychologically, and really being in fear of my life. I mean, the fact that I didn't know where I was and that I knew no one else knew where I was, that really loomed rather large in my mind. And then there was the push-pull dynamic. On the one hand, the threat of harm, and then this false life preserver that he had just thrown me. So the cumulative effect of that was that I falsely confessed. I made up a story based upon information which they had given me in the course of that interrogation and in the 6 weeks prior to that, when they would periodically meet with me, and half the time they would talk to me as if I was a suspect, and the other half the time they would be talking to me pretending to need my help to solve the crime. So in the course of that routine, that's what the run-up to the day of the false confession was. In fact, that's how they got me to agree to take the polygraph. They told me, well, we have some new information in the police file, we want to share that with you, and then that's going to put you in better position to help us. So just help us to help you to help us. So getting back to the false confession here is that the details that they had given me is how I was able to craft the story. And by the time it was all said and done, I was on the floor, I was curled up in a fetal position, I was crying uncontrollably. I was so frightened out of my mind, I was speaking faster than what I could craft in terms of the story. So needless to say, I was arrested. I was charged with murder and rape. The prosecutorial misconduct and the fraud of the medical examiners is important to understand in brief, because the prosecutor got the medical examiner to commit fraud, to come into court and claim that he found medical evidence showing that the victim had been sexually active, which is what opened the door for the prosecutor to falsely claim that it didn't matter that the DNA didn't come from me because she might have had sex with somebody else voluntarily. And at the same time, my public defender was terrible. I mean, he never cross-examined the medical examiner. He never explained to the jury what the significance of the DNA matching me was. He never argued that proved that the confession was coerced and false. He never presented to the jury my alibi. I was actually playing wiffle ball at the time that the crime happened. So the sum total of everything was that I was wrongfully convicted, and I spent the 16 years in prison. I mean, I lost 7 appeals. In fact, one of the highlights or lowlights, however you want to dress up the description. At the appellate division, when I went to the first appeal, I mean, the appellate division wrote in their opinion that there was overwhelming evidence of guilt, which I don't quite understand that ruling really to this day. The DNA was in my behalf, and the only other evidence was this confession obtained under highly questionable circumstances. So from there, I also got turned down for parole, I think in part because I stood on my innocence rather than expressing remorse and taking responsibility, and in every other way I was really kind of an ideal candidate considering my disciplinary record and the educational accomplishments I did while I was in prison. Ultimately, I obtained the assistance of the Innocence Project, and they agreed to represent me. As Mark mentioned, Pirro left office, DiFiore took office, and I think really what happened was Baryshek was really the bigger public figure at that point in DiFiore's career, and so she allowed me to have the further testing, and so it matched the actual perpetrator, who was subsequently arrested and convicted. I mean, not only did he confess to the authorities, but he also confessed to a reporter on video camera. So, definitely no false confession or coercion there, to be clear. So when I was released, I gave an off-the-cuff 2.5 hour presentation to the media, really saying everything I had ever wanted to say in the course of the 16 years and really could never get anybody to hear. And so it was at that moment that, a light switch went off in my head, and I realized, I could be part of the innocence movement without necessarily being a lawyer. And so I found a mission in life. I found a purpose. I found a silver lining. I felt like, it's my job I'm here in the world, and that's how I make sense of what happened to me. It's up to me to fight the wrongful convictions and to be part of that effort. And so I embarked on this advocacy trail, with my newfound identity, from doing presentations to being a columnist for a weekly paper for 5 years to trading privacy in exchange for awareness and doing media interviews and meeting with elected officials and going to hearings. And simultaneous to that, at the same time that I was doing that, I got a really generous offer from Mercy College to finish my college degree. I had gotten the GED in prison and got the associates and was 30 credits short, which is to say 10 classes short of getting the bachelor's degree, but they're giving me the scholarship, and so I finished the bachelor's degree, which I never would have done because I rather foolishly was thinking at the time, I'm too old to go to college. So that intervention was really, I look at that as a key moment in my life post-exoneration. So I got the bachelor's degree, and from there I got the master's from John Jay with my thesis written on wrongful conviction causes, and at the same time I was pursuing the litigation and seeking to hold people accountable to the extent that I could. I mean, really, people should have went to prison for really what was done, but the most justice I ever got was on the civil side. And so, I wanted, when I got the money, I wanted to take the advocacy work to the next level. I wanted to do things I could never do as an individual. I wanted to be involved in reaching back for people. I was tired of just doing the awareness and the policy. I wanted to actually help free people, and so I committed a few $1 million of the money, to start the organization, which Mark mentioned the name of, and it's been a really nice run. We've been around for 4.5 years, so we exonerated 2 people in the 4 years. We exonerated William Lopez, who was in for 23.5 years on a shotgun murder out of Brooklyn. He had pre-existing lawyers that were with him for about 9 years, but they needed us on the investigatory level. So it's kind of like a building was built, but it was missing a section, and so we helped to put that section in, finding some additional evidence, and he was exonerated. Kind of like how Mark mentioned in his the story of his first exoneration, where he took comfort in that his client was free for a year. So similar thing with Lopez. He lived for like 1.5 years afterwards. But we went, but I think that was really the best year and a half of his life. And then not long ago, maybe like 6 months ago, another Putnam County case, foundation, we helped to exonerate William Hawley, who was also from Putnam County, who was in for an arson case that actually really was like an electrical fire. In order to undo a wrongful conviction case, you have to find something new. I mean, you might assess the record yourself in terms of, making an educated guess, do you believe in someone's innocence or not? But that's really what motivates you to go forward on the case. You can't go back in a court and relitigate what is already there, so you really have to find something new. And so in 3 instances, we were really, the record was fairly clear that our clients were innocent, but we didn't have anything new, and so they were making a parole board appearance, and so we wrote letters to the parole board outlining the primary and secondary reasons why we believed that they were innocent. And it carried the day. We're like 3 for 5 on those, and so 3 other people were out, albeit not exonerated. Our goal is still to clear them, but at least they have some measure of freedom while we still look for other ways to try to get enough evidence to clear them. The organization, we were able to do the work that we did really because I wrote a large check every month is what it amounted to. And so I did that for like 3.5 to 4 years. I rather naively thought that I could just have a program, just have the programmatic side, just have the legal professionals to do the work, and I could do the advocacy stuff, and I would just meet with donors, and, since it's my name on the door, and no money's coming to me, but to the contrary, money went out, who could question our authenticity? And so I thought that, people would I'd meet with potential donors, they'd write checks, and, we would keep going. But after doing that for, 3.5 years, we really, our fundraising efforts didn't go well, and so we reached to the point where, we had to just convert to, just having a volunteer staff, and we still have the staff attorney finishing up a few of the cases that we were close on, but beyond that, we have other people doing the volunteer work, and fortunately, really for us, 4 different law firms have stepped forward with some others potentially on the way where cases that we screen and pitch to them, they'll consider taking on a pro bono basis, and through which the foundation would remain involved on a strategic and consultative level, and then chip in with some timely PR work when the moment's right. So, really, what I'm hoping, what I hope, I remember, I remember talking with some people and discussing, the difficulty in raising funds, and, there's a website called Patreon, which, we have a modest campaign there, and, my crazy idea, right, my dream. So it's great to have the volunteers and have the lawyers, and you need that, because this is very labor intensive, but you also, to really be robust, right? You really need to have, in-house staff. So, my crazy idea was to have, what if there were 25,000 people who could afford $3, on a recurring basis? I mean, to then have investigators and lawyers and other relevant staff, and to, maybe one day, have a few large donors. So I still retain that dream that I carry around with me. We have like 600 raw cases, unscreened. People have been waiting, 2, 3, 4 years just for us to vet the case and determine, do we believe in their innocence claim? Is it at least plausible what they're saying? Is there a path forward to try to exonerate them? So I think about a lot of those cases. I think about those cases at night. Some of the people that the foundation's still working with. So one of our clients actually is here tonight. Wayne Drummond is here, and we're still working on exonerating him, but he's home on parole. But he's not content with being home on parole. He wants to have his name cleared as well. He should. Other people really who are here. Mark talked about Anthony's story, and Anthony talked about his story. But a name that came up, a few times in the course of the story was Krivak. They mentioned the name Krivak a few times. So Andy Krivak really is Anthony's co-defendant. The same polygraphist, Daniel Stevens, who did what he did to me with the polygraph and using that as a coercion vehicle, did the same thing to Andy Krivak. The prosecution theory was that, they did the crime together. Anthony's home. Andy is still in prison. That doesn't make sense when you're claiming that they did the crime together. Andy's post-conviction motion requested a new trial, in part based on the newly discovered evidence that was not available at the time of trial, that Daniel Stevens, who did what he did to me, did that to Andy, so he couldn't bring that in to challenge him about what he did to me in order to show, look, you've done this type of thing before. So as far as, we're concerned, we thought that was a really solid ground. And then also all the evidence as against Howard Gombert. I mean, just like Anthony was able to get a new trial and, have the right to present that, I mean, that was our argument, was that he should have, Andy should have the same right to present that same evidence. So part of the way that the court evaluates that is, whether they evaluate whether or not the new evidence would probably have changed the outcome. Well, we thought we had a great argument in and of itself. But when Anthony was acquitted, that's proof positive that yes, in fact, there would have been a different outcome. And so we kind of thought this was kind of went without saying that he was going to get the conviction overturned. But when the judge issued his opinion, the same judge as Anthony had in his trial, the judge went back to a 1981 treatise in which it referenced, that to paraphrase, that a confession is the most reliable type of evidence you have, right? Let's just forget about through DNA evidence showing that false confessions have been the cause of wrongful convictions in 25% of the cases. Right, being, rather unreliable form of evidence. He wrote in his opinion, I couldn't believe it, that he thought that was the most reliable form of evidence. And then he made short shrift of all the evidence as against Gombert. He said basically, well, all this evidence against Gombert really, that wouldn't have done anything at all compared to the confession and compared to the corroboration of the confession. What's the corroboration? Well, corroboration is, well, in the confession it contains details, right, supposedly that only the killer would know. But we know through the DNA cases, in my cases, and other cases, that often, although that's the claim, what happens is in the course of the interrogation, either deliberately or inadvertently, the details are conveyed, to people who then parrot it and incorporate that into their statements. And so, the new trial motion was denied. So we're obviously appealing that, and not just on the fighting in the legal arena with the appeal, but also on the public relational aspect. We were able to pitch the case successfully to Victor Sipos, an attorney who's handling the case pro bono, and he also brought in Adele Bernard, who had represented Andy Krivak at an earlier stage of the case prior to him coming to us. So we're challenging that, but we're also fighting fairly aggressively in the public relational arena. We all feel very strong, that Andy has just as much right to his freedom, as Anthony has. It's kind of a travesty that they're both, that he's still in, Anthony's out. So I'm going to close out with this. I'm often asked, what is the percentage, Jeff? What do you think the percentage of wrongfully convicted prisoners are across the country? And because I know that the answer I give is going to be met with skepticism, I always, before saying it, I support it with all of my reasons. And so I'm going to style my answer to you tonight in that fashion. So 13 people that I knew and did time with while I was incarcerated were exonerated either before me or after me in the course of my 16 years. In Brooklyn, when there was a new district attorney elected, Ken Thompson, who had replaced the prior DA who had been there for 23 and a half years. He beat the incumbent in a primary in a race that was really decided in large part on the wrongful convictions. So the new DA running on the wrongful conviction issue set up a unit, a conviction review unit, and in the 2.5 years, 23 people were exonerated. And it's like they would have never saw the light of day had the incumbent stayed there, and there's no reason to believe that was limited only to that one jurisdiction. A lot of the other areas where the incumbents have been there for a long time, who knows how many more people are still in prison there, but unable to be heard. Last year, it was 149 people were exonerated nationally on a DNA basis, 139 the year before that, and the 2 years before that, it was 91 people. The National Registry of Exonerations, which tracks all the exonerations, both DNA and non-DNA, they're around 2,000. I don't have the exact number memorized. I did at one time, but I've forgot. But you can look it up, but it's close to that number. And that's really the people that make it out, though. I believe it's kind of like the iceberg. So what you see above the surface is just a small part of the whole. And then when you think about how for many years, what was accepted as evidence in the courtroom that had an air of being scientific, but actually wasn't scientific, that's been admitted as evidence, whether we're talking about tire tracks, footprints, bite marks, voice recognition, bullet lead analysis, where we're going to pretend that we test the bullets for the chemical composition and be able to determine where the bullets were made and trace where the bullets were sold to my favorite, which would be laughable. It would be great Saturday Night Live material, except that people were wrongfully convicted based on it. Dog scent testimony. Right? I kid you not. You did hear me correct, okay? I said dog scent testimony, where we're going to give an item to the dog and he's going to smell it, and and then he's going to be given something from the defendant, and if the dog barks, then that meant that he recognized the smell. When you think about all these things used as evidence, I think that the percentage of wrongfully convicted people is 15 to 20%. So that's why I do the work. That's why the foundation has the mission that it does, and that's why I'm in law school. I'm hoping to exonerate some people personally, not just through the foundation. And listen, thanks so much for hosting and coming out to this event.
Just another quick round of applause for our speakers. This was a really incredible night. I want to thank each of our speakers. There's a lot of darkness in the criminal justice system that we've heard about, that we know about outside of here, and each one of you in your own ways represents a light. Jeff, the work you're doing is so inspiring, and you are showing us that sometimes you have to do the work yourself if you want it done right, and thank you so much for being that voice, for being that movement. You're an amazing person, and we're so lucky to have you here with us tonight. Anthony, you stood up here with a huge smile on your face and your positivity and your eye towards the future. It's really nothing short of inspiring, and we're really lucky and honored to have you here with us tonight as well. And Mark, thank you so much for agreeing to speak tonight. You're a real hero that sits amongst us here in Shul. We're so lucky to have you as part of our community, and it's inspiring for us to hear about the work you do. We see you here on Shabbos, but to actually hear about the work you're doing from you, it's been incredible. Thank you so much for being an inspiration for us to stand up for what's right and put your whole heart into things. Thank you. Because the hour is late, we don't have time for questions, but Mark's going to stick around for some questions, and if Jeff, Anthony, if you want to stick around as well, feel free to go up. Thank you so much for joining us. Have a good night.